Good evening, everyone, and welcome to Legal Contracts and Policies Board meeting for Akron Public Schools this evening on Monday, May 19, 2025. First order of business is the minutes from last meeting. Do we have any questions, comments, concerns for the meetings of last meeting? No questions, no comments? No questions, no comments? Okay, we'll move on. Next, we have public participation. Is there anyone in the audience who wish to participate today? Anyone in the audience wishing to participate today? We have none, so we will move on to our order number 3 as a discussion on topics of the Parents' Bill of Rights. Ms. Carter?
So we had this up for discussion at the last meeting. Today we're having it on here as a first read. And so go ahead, Haley.
Oh, sorry, Ms. Carter. So I just wanted to point out the change that was made. On the second page, you'll see the language that's crossed out. Something that came up in our last meeting, the last time this was discussed, was this and/or contracted services portion. How would the district monitor this? Are we really required to do this by law? The answer is no. So why Neola included that in the first place, I'm not sure, maybe as a catch-all, but the district isn't required to monitor what its contracted services are per that statute. So we went ahead and took that out.
Okay, good.
Okay, thank you, Haley. Next is electronic equipment.
Wait a minute. I'm gonna back up. Any questions? I'm sorry. Questions on this policy, Parent Bill of Rights? I'm sorry. That's my fault. Dr. Molnar?
Thank you, Mr. Chair Alexander. Sorry, for a second from this angle, the new table, I thought it was still my name there. I was like, we don't have this. Okay. In this section with contracted services, exactly where you were on this page, I know that when this was first brought to this committee, we talked about the relationship between another policy that I actually did not write down, but there is another policy that deals with student bullying and harassment and things like that, and we decided not to reference it, but in that policy it talks about an investigation, and so I wonder if here, instead of like and or contracted services, if there's an investigation that the student is involved in, that the parents would be notified. That is my first comment. Actually, my first comment also, the board and or school personnel, and it feels like that's a lot. Does it matter that it's the board and or school personnel, or can we just say the parents will be notified? Because we aren't clarifying here who is notifying them anyway. And if you read the rest of the policy, it just says that they'll be notified by the school, it's, down, school students building administration. So I'm curious about that. That's my second. And then the third, I would appreciate here, as we mentioned before also, to have a real time frame in here. They will be notified, but when will they be notified?
Okay, go ahead.
Thank you, Mr. Alexander. So, Dr. Molnar, yes. So with regard to your second point, that's definitely a change I could make, and that'll make the language a little bit cleaner. With regard to the point about timelines, this is something that we discussed with Dr. Lash, and she suggested maybe putting this in an administrative guideline. And I don't know, Dr. Lash, if you wanted to speak to anything further with regard to why we would put something like a timeline for an investigation in an AG as opposed to in the policy itself. But I think that the intention is to give the district the opportunity to figure out how exactly this is going to play out. Neola should be giving us an administrative guideline with regard to like forms and procedures with regard to how the Parents' Bill of Rights should actually be implemented. We haven't received that quite yet. But I think that that's something we can continue to explore. Dr. Lash, do you have anything to add?
Not necessarily, Attorney Kepchar. Good evening, everyone. It does, if I'm not mistaken, use the word promptly, and in the policy, Dr. Molnar, that you referred to for the investigative part, that relates specifically to alleged reports of bullying, it does use the word promptly, but I agree, yes, administrative guidelines, which governs how we carry out the policy, would be a great place to include that time frame.
All right.
I might have follow-up.
Okay.
Well,
Pastor Harris, go ahead.
I just wanted to address that administrative guideline and push back on the use of administrative guidelines when we have a definite time for something. Administrative guidelines is how we internally will do something.
Correct.
The policy is for people to know how we should do something. And so promptly, you know, if I'm a parent and nothing's going on, I would think promptly would mean as soon as I can. But if I'm a parent and something is going on, I want to know when I should have been notified. And so the use of administrative guidelines, while it is good for internal, standard operating procedures across the district, I think when we're doing policies and we're trying to inform parents on what should and should not happen, and I'm for the other members, what I'm thinking in my mind is some of these executive sessions we are having, things have been unclear, and the administrative guidelines may not have made it clear. A policy makes it clear. And so if we're doing something with a definite time, I would really like to see that in the policy, because that doesn't change, and it takes a change of the policy, not the guideline.
Anyone else? Dr. Molnar?
Thank you, Member Alexander. Yes, to follow up on what Member Harrison said, promptly, your version of promptly and my version of promptly might not be the same thing. But I also understand that sometimes you don't know when something is going to end or how long something's going to take. But also as a parent, to not know that something is happening and that an investigation is occurring and that your child, your student is involved in an investigation and you have no idea until it's over, that also could have consequences. So I would like to offer some language ideas that I think might be a compromise. So we can say that the student's parent or guardian will be notified within 24 to 48 hours, whatever that timeline is, of the notification of it starting, and then just to let them know something has started, something has begun. The school is aware. We want you to be aware that we are aware, and we're doing something, right? And then the follow-up language would be, upon completion of the investigation or review, the school will provide the parent or guardian with a written summary of the findings and any resolution or any actions taken. So that way it's two parts. So we might not know everything that's happened right away. We'll let you know what we know and then follow up with you.
Okay, any other questions on that? I do have a comment if we don't. I like the idea, Dr. Molnar, of kind of putting that in there, but I don't want to box us in either. So to say 24 hours, we may not be able to get it done with 24 hours. So we probably need to say, if we're going to give a time frame, make it long enough that if, maybe because it may have happened on a Friday and then we're starting to work on a Monday, that we give enough time for staff to be able to do that work. Okay. So maybe we could put something there like that.
Sure.
I mean, Dr. Molnar had a good idea. I like the second part of her piece, but the first part, I think we need to make sure we have enough time so that we can get the work done.
Okay.
And make sure the parents be notified.
Noted.
I'm sorry. Any other questions on that? No more questions? Okay.
All right, thank you.
Carter.
Next is electronic equipment, and I'll let Attorney Kepchar. She did make the noted change in this, and I'll let her talk about that.
Thank you, Ms. Carter. So per some of our discussions with regard to referencing a policy within a policy, we went ahead and dropped a footnote at the end of the first paragraph, which explains the exception that we're referencing. So that's the bold footnote that you'll see at the bottom there, which states students are prohibited from using personal communication devices or other electronic equipment during the school day, including while off campus on a field trip, except as authorized by a teacher, administrator, or IEP team.
Okay, any questions on this policy or anything that the attorney just mentioned to us? No questions? Okay, let's continue.
Okay, so then we would be ready to move that to a second read. I'll have Mrs. Folk come up for purchasing and bidding.
You ready? I'm sorry, hold on. Let's see. You had another question, Pastor Harris?
Yeah, you got to slow down so we can get the.
Oh, I'm so sorry.
Yeah, so when we're talking about the first and second reading, are we moving this to the agenda for first and second reading?
Well, actually, one of the a reading could be now. This will be a reading.
Okay.
And
This
we
would
go
be-
to board meeting next. That could be another reading, and then we can go to following board meeting. Could be another reading. It could be three readings, within a committee meeting or within the regular board meeting.
Okay, okay.
Okay.
All right.
Continue on.
All right, Ms. Folk?
Afternoon to Chairman Alexander, co-chairs, and members of the board. At this time, this is an update from Neola regarding purchasing and bidding. It's not called just purchasing anymore. So please, as we go down, the big change in this policy, if you will go down to competitive bidding, is the area in green that now says the amount to be determined and published by the Ohio Director of Commerce. This is a note to enlarge or improve, and this went into effect in October of 2024 under a state statute that is now, instead of $50,000, it has been raised to $75,000, and this allows an automatic increase of 3% each year thereafter. So this would allow us to, when we are building, repairing, enlarging, improving, or demolishing a school building, the cost would be allowed to, if it was under the $75,000, it does not have to be competitively bid. Once you hit the $75,000, it is to be competitively bid and automatically then increases 3% each year afterwards. So the next time it would go out, for the next time period, that 3% might be, say, $76,000 or $77,000. And that is a state statute update.
Any questions?
Yeah.
Pastor Harrison?
So the state statute, yeah, I'm aware that went up in 2024, but we have a board policy, correct?
Yes, your board policy currently says 50,000, but it is always relevant to be in line with the state, because many of the state contracts and other things are bidded by state cooperative groups, and they will follow the competitive bidding statute under the revised code.
I thought the district had a threshold.
It currently, as you can see, it's crossed out there at 50,000.
That was the state's. I thought the
That
district.
the state and the district matched at the time period. Now the state has changed theirs. You still have the requirement at the top of this particular item. You will solicit at least 3 bids when it's more than $10,000, and anything being approved by the board at $25,000 or more needs your approval. This is just a change to the competitive bid statute.
Any other questions? Dr. Molnar?
Thank you. I don't own a company. So can you please help me to understand the difference between the $10,000 threshold as we have it currently and the $50,000 threshold as we have it currently? Because it looks like at $10,000, we still need to do 3 bids.
3 quotes, but it's not a competitive bid. You can actually go out for a 2-week bid to ask or call 3 companies that would be allowed to give you that kind of service or equipment and get them to give you a quote. It doesn't require the competitive bid statute.
And follow up, if I may. So then at $50,000, which is our competitive bid currently, even though the state moved theirs up to 75, would we be penalized if we stayed at 50, even though the state allowed up to 75, but we continued to have competitive bids?
I would let that go to legal.
So I think, Dr. Molinar, if I understand your question correctly, you're asking if we were to keep the bidding threshold at $50,000, if we'd be penalized. Off the top of my head, I can't answer that question, but I don't think that there would be any penalty for leaving it at $50,000, but I think that the district administration, it sounds like it would be helpful to follow the state statute of the
That is correct.
75,000. But to answer your question, no, I don't believe off the top of my head that we would be penalized, but we would have to look into that, and I don't think we would find anything that we would.
Anything else? Follow? Oh, okay. Reverend Harrison?
I think that's an example of where the administrative guidelines come in. So when we're looking at the administrative guidelines, and that's what I was looking for, the 10,000, the threshold that we have, but whatever we set the competitive bidding threshold at, as Member Molnar stated, I think that's where that's where the administrative guidelines become useful in establishing our own district, the way we do business. So I just wanted to use that for an example as opposed to the policy administrative guidelines. That's where the administrative guidelines come in.
I can advise, if you go back to the top, the original $10,000 listed here in paragraph 1 originally was $3,000. This is a number of years ago. The board revised it at a time to $6,000. The last time it was revised was at 10. So that was, keeping up with the economy. The $25,000 for board approval has been an established period for a long time, and we have always, as alluded to here under competitive bidding, we've tried to keep it in line with the state's requirements. So that's why when we saw this come out from Neola. The other thing that's very important to this is that automatic increase by 3% each year, because that allows a movement in the market. So therefore, if we could go, as an example, to 75,000 and put it out for bid, but the next time we want to do something, if the 3% now becomes 77,000, then we could still do your 3 quotes, but it doesn't necessarily have to be a competitive bid. And this is only 6320. This does not get you into the other one yet, which is the next one you get to see, which is the federal statutes, and they're different than this is. Thank you.
Any other questions? Dr. Molnar?
Thank you. So can you help me to understand, or anyone who's watching to understand, since it sounds like this would benefit the administration to raise the threshold in which, so right now, if someone's $55,000, we would need a competitive bid. If we pass this policy, $55,000, we would not need a competitive bid. Can you help us to understand how that would help the district?
All right, so therefore, a competitive bid has some statutes to it as to how long it has to be out. It's a minimum of 30 days. When you are looking for 3 quotes or 3 responses to what you need, they can come in within a couple of days, a couple of weeks in order. And sometimes and you have seen this in the past, we've had to do urgent necessity replacements. Just think of a boiler. And therefore, when we had to do that, we had to write it in such a way to actually eliminate the process of competitive bidding under another statute. So if the boiler was previously $60,000, we would have had to competitively bid it under an urgent necessity. In this case, going to $75,000, we can get the appropriate quotes, the appropriate installation, and get it done in a timely manner for the board's approval without having to do the urgent necessity statute.
Any other questions? So, Ms. Folk, so this is basically so that if like you're saying, if we had something was an emergency, that you would not have to use the 3 bids. You can go out, get it done, and then
We would
come
still
back.
look for 3 quotes. We wouldn't have to do a 30-day minimum bids time statute.
Right.
Yes.
Because if you need something right away and you got to wait, then you can't get it until you go through the
That is
process, right?
correct.
Okay. I just want to make sure so it was clear to everybody, including myself. Okay. Any other questions on that? Okay, next. I'm sorry. Can we make sure that to check too, to make sure we don't get in any trouble if we would go below that with
What stay at
I'm sorry,
50?
with the 75?
Meaning getting trouble with what?
With the was it not Neola, but with the state? Who was that?
ORC.
ORC.
The ORC.
Yeah, the ORC, I'm sorry. So-
I think Haley answered that question.
Yes, but I can look into this and make sure that the statute doesn't say
Right.
anything like that. I don't anticipate it will, but yes, we'll make
Right.
sure.
That way, I just want to make sure it'll be
Of
clear
course.
to everybody here, and even the people out there who are listening, it'll be clear. Okay, I'm sorry. Thank you. Go ahead.
Thank you. Not sure what's
All
next.
right. Next is vendor relations. And we did have our discussion regarding adding in a line here as it relates to if a vendor has a complaint, as well as the ICO and service provider policy as well. And we've started actually looking at the checklist on providing a way for people to submit their complaints. And so that is currently in draft form, and we just sent that to legal for them to look over as well, because again, we want to make sure that the process that we have in place, that it is, we want to make sure we're not treating contractors as employees. And so we're having legal look that over as relates to what we've come up with. And so we would need to decide where in the vendor relations policy we want to add that line. And then also when we're looking at the ICO one as well, we need to decide. I have an idea of where we could put it for the ICO one. And then we can discuss where we would put that as relates to submitting a complaint in the vendor relations one. We did discuss the changes in here, unless there was anything different added to this.
Any questions? Reverend Harrison?
Yeah, I think, thank you, Mr. Chair. I think it was more than a line to be inserted. I think what, I had asked to kind of see a clear path for vendors to resolve any type of dispute. So more so than a line, but a guide for them to follow before we are, again, here at a meeting trying to determine the merits of, was something fair or not. If the vendors have a prescribed procedure that they can follow, then I think that would serve the district and the vendors, all vendors.
Okay. So then once we get that feedback back, then we'll insert the process into here, and then we can play with that once we insert those, that information.
Anyone have any other questions? Madam Chair?
Yes, just very quickly. So I know I talked about this regarding teachers' intellectual property for this first paragraph. And I think the part where I'm concerned about were not created during their employment, because I believe that teachers should still be able to have ownership of their intellectual property. I think the wording that I was going for in the last time is that it was not under the hours, because I did look into it as far as how you can't get paid for work that you create while you're on the clock. And so the question was, as Ms. Falk explained, that this was fun, or maybe it wasn't Falk, someone explained that these are funds received from a grant, they're able to get to materials, and then they execute whatever during their work hours. And so what I would like to posit is, as an educator for 20 years, there are times where there are certain things you can do outside of your contractual hours. The same way we have these supplemental contracts where a teacher can be a coach or something outside of their direct instructional hours. So I'm just wondering, just very quickly, that wording, if we can reword, not that they're employed for the district, but during their contractual hours. Yes, I'm
Thanks,
sorry,
President Jackson.
Mr.
Sorry.
Chair.
So this is something that we touched on briefly in our discussions with administration. And in general, materials that are created by employees within the scope of their employment are considered works for hire. There is a way, I think, that we might be able to carve something out here, that, with the caveat that this is a pretty complicated legal question. So we would need to have another attorney perform like an intellectual property analysis. They have a completely different. Like we have certain intellectual property attorneys and they have a different bar exam and everything. So that's something that might take a little bit more time for us to get fully fleshed out. But what we could do is maybe add a footnote that perhaps like if a teacher had a specific inquiry that they could bring to us, and then that way we could look at it as a case-by-case analysis. Would that be something that might make sense here?
Yeah, I'm in complete agreement.
Yes.
As long as the individual could have some say so and they're not boxed into because they work here. They've developed this over the summertime hours or weekend. You know what I mean? I just didn't want it to be where they were boxed into that they cannot have ownership of what they intellectually created, spent hours and in a very innovative on their own outside of their contractual hours. So I think if they're able to ask the question in this way before they enter into it, or inquire, that will protect them in some way. I'm just worried about the protection of the teacher's intellectual property that's outside of the domain of their higher job, without costing the district right now more money for billable hours. I don't want to get us into that. Okay.
Reverend Harrison?
I'm just wondering if it would be, instead of doing case by case, if we could maybe possibly look at having a shared users agreement, and then the teacher, administrator, I know I'm going to create this, and so I go and say, hey, I'm going to create this. Can we just agree up front that this is a shared users? I retain the ability to present it at conferences, or as well as the district retain. Would that be beneficial maybe to have something up front so that we don't have to look at every situation? Like an agree, does that make sense?
Madam President?
I hear you. I'm not in agreement with it, though, because if it's the teacher's proprietary information, right? I'm talking about because you have some excellent teachers going to go far beyond what the grant provides or what they do, and like some really good instructional strategy, whatever it is, right, that they create. The reason I have an issue with the shared use because now the teacher doesn't have the district possibly can still capitalize off of that intellectual property, and the teacher does not have the control when we're looking at how it's being rolled out. Akron, with having a platform that they have, if they do their own PDs with it from other teachers. Right. So that's my only thing. And not to belabor the point, I'm going to yield my time, and then that's the only issue that I have. If it's a way for because all teachers may not have the same what I have, but then there are teachers that's just like me that know what they put in and know it's their brainchild, and so they want the ownership of it to some degree, what they bring to it. So
so that's I guess in that saying, would it not be beneficial to have something in place where if it's not proprietary, or if the teacher wanted this, I'm creating this, and so we just in advance have an agreement. I guess I'm looking at not doing every single case, but maybe I come to you in the beginning and say, hey, I'm about to create this. I want to retain ownership of this. Do you agree? And the district says yes or no.
Go ahead.
Sure, I cannot answer that question at this time. I'm not sure if that would be something that would be permissible. Off the top of my head, I'm not an expert in intellectual property by any means, but if the committee's agrees that that's something that we should look into doing, then it certainly is
I
something that
think
we can
that's
look
the
into.
superintendent's call. I think that's the superintendent's call. If if you want to grant someone their stuff, I think I'm not talking about legally because Motown, they're gonna give you your stuff or they're not. But I just think that we could maybe look at that, a release, so we're not looking at every single case. Maybe I come and I say, hey, I want to create this and I'm doing this, but I want to retain proprietary rights to it. And the district can say yes or no, and if no, then you go. We're accessing legal for a lot of stuff, I think, that we can agree to.
Okay. Yeah. Let me say this here. Why don't we look into what's going to be the best case scenario for APS in doing this type of stuff, and then come back and talk about it again, because we don't want to go too fast and it's something where I'm one that working with attorneys all the time. I'm always looking for legal help, so I'm going to lean towards legal as well when it comes to that. But why don't we allow that to happen if we're okay with it? Yes, Madam President.
Mr. Chair, I just want to be very clear, because this is my own, I don't know that this is a whole board concern, so I would not want to use any funds or any billable hours to dig where this takes days worth of work and we are getting billed towards it. I just thought I would posit that there. I don't want you in the legal to spend like hours or research or getting experts and we get a bill. I think I just put it in this platform so teachers, teachers were smart. So if they do have that, to your point, and they have a certain position, then they can look at maybe what their standing is and how far they want to go with it. I just don't want to be the board, because I'm individually, this was my questioning, and the board, I don't know that it's a board concern. It's a teacher, Carla, principal concern personally, just because we create things. So I don't want to, I just want to go on the record. I'm not asking for her to do anything additional than what she's brought. I thought she would be able to respond here. I just don't want to see on the back, because I'm still waiting on an itemized bill for legal things.
Right.
So I'm
That's
very serious with that. Okay, thank you.
Because maybe that should come from superintendent or her designee to bring that, and if they think that we need to move forward, then they can move forward that. Or if it needs to go to legal at that time, let them do that versus us having to do that now. Is that okay with everybody? Okay, I do have one more comment too before we move on. I'm talking more than I ever talk. With this vendor piece, and we're talking about if a vendor has a complaint, why not do a form possibly? A form, they have a complaint, they fill out this form, they get it to, and then we discuss it. That's just a thought to throw on the table with it. Okay, all right. Any other questions on this piece here? If not, let's move forward.
Next is the ICO service provider policy, and we're proposing for it to go under 6460.01, which would be like a sub-policy under the vendor relations policy. And then the addition will also include the process to submit a complaint under this too. And then I'm thinking that we could put that under section 6 of the policy. We'll work on that, and then we'll add what we have in here once we hear back from legal. And then any questions? Because nothing has changed since our last meeting. Dr. Molinar?
Yes.
Thanks. Yes, I have a series of questions. But first, when we talked about forms, I know the last time that I was involved in this conversation, we talked about the independent contractor determination form being an administrative, listed or outlined in administrative guidelines. Is there a copy of that form available to us before we move forward with this policy, so we can see if we're removing something from the policy and putting it into administrative guidelines, what that would be before, if we're going to change the policy, we should change it now, right? So do we have that independent contractor determination form available for the board to see what that would look like?
No, I don't know what you mean by the determination form.
So when we first started talking about independent contractors, I'm going to say October of 24, I provided everyone with draft language and ideas for the independent contractor policy. And then in maybe February of this year is when we started talking about this policy. And I said, why, what happened with everything that I brought to administration in October? And then the conversation was, it was determined that everything that I brought in October was going to be used as an administrative guideline, and that's why it wasn't going to be in the policy. So then I was wondering if those administrative guidelines would be available to us so I could see how that would complement the policy and all of the pieces that are missing.
So the idea of it being administrative guidelines was a lot, like, that was discussed here, and it was decided that, no, it's going to be a policy. And so we actually went through the information that you had, and we actually updated this based off of some of the information from the first draft that you had brought to the table. And so some items have been inserted from what you had into this, and plus some additional things were added as well, like the Ohio Public Record Act, some of that stuff down in Section 6. The violations of this policy may result in termination of contracts and potential legal, and then the revised code, that was an addition. But it was determined that this would be a policy and not administrative guidelines. Because at first we were thinking that because we had the vendor relations policy, that we would just do administrative guidelines. But the committee chairs said that they wanted to be policy. So we kept it as a policy, not administrative guideline.
So follow up, just for people who are catching up. So definitions, when they said some of the items were kept and some of the items were not kept. Definitions in the policy that's available here, there are 2 items. I had 5, eligibility and requirements. There are 4 items here. I had 16. But to start with, for this conversation, my recommendation was to actually start the policy not in the purpose, not just saying the purpose of the policy is to establish guidelines, but also to state, and I'll just read what it started with. So an individual who is paid to provide services to Akron Public Schools must be hired as an employee unless Human Capital has an independent contractor determination form on file that determines that an employer-employee relationship does not exist for the scope of work based on criteria established by the Ohio Department of Job and Family Services or a higher-ranking government authority. So that is just one sentence that I thought was really critical, especially given the year-long situation we've been having with van drivers turning into vendors and that process continuing to unfold. So I'm wondering if someone could help maybe unpack why we don't have an independent contractor determination form, or why we don't have a statement about why they must be hired as an employee. And yes.
Okay, I have a question. Are they hired as employees? I thought independent contractors are independent.
Are not employees.
Okay, because you said employees, that's what.
Yes, so basically, the default is they must be an employee, and then the specialty is unless they check all the boxes of independent contractor. And if they check all the boxes of independent contractor, then they can be an independent contractor. So the default is employee, but then they don't have to be hired as an employee if they're eligible to be an independent contractor.
Right. I'm just thinking an independent contractor will not be an employee of the school.
Right.
So we won't have to have anything to say that if they're not an employee, because this is independently and not employee. So we take the employee piece away and we just do the independent contractor piece. That's what I'm thinking of. You guys help me out if I'm wrong.
The form explains why, though.
Yeah.
Okay.
So,
I'm sorry, Madam President, go ahead. I don't want to get.
I think that the for the clarity part is on the form, the identification of the form, not employer, not because with employees, then you're thinking about benefits and other things that have to come. And for the independent, because this is for contractors, service providers, that they should be independent. But I believe, if I'm understanding what Member Molnar is positing, is that, because I was unclear too at the time of that discussion, does a form exist that identifies these are independent contractors? There's no gray area. Outside, I'm saying we don't need, I'm in agreement with you, Vice President Alexander, the employee, them being an employee is not either or, it's period, because we're talking about independent contractors, service providers, that's individualized, that they're not on our benefits, they're independent, they do a 1099 or whatever. But there, as I understood, and Member Molnar can clear this up, but that there was no form. Like we said that they were, or were they? What? I'm sorry I didn't mean to be so animated. That it was not an actual where we can pull and go to a file and see they clearly know they're not employees of the district, they're independent contractors. They filled out this as independent contractors. So I'm sorry, that's what I just wanted to, from my understanding, when those conversations were happening earlier, that it was gray area and they had been operating almost as if they were dual employees of the district. And I say dual, meaning they were functioning like employees, but they were believing they're in ICOs.
Right.
You see, and so to make that was this is just how I'm unpacking it. I may not be on par. This may not be what Member Molnar is positing, or it may be, but that is clear.
Right.
That what they are.
Reverend Harrison, go ahead and then go back to you.
So there is a federal form that identifies independent contractors, but and I'll use the van drivers as an example, because that was when they were told what they could wear, what they couldn't wear. Okay, they were independent contractors, but we were directing their service, which we can't do as independent contractors. And so that's where it started to create a gray area. What can we say? What can we do? What can we not do to independent contractors? I want to go back to Member Molnar's question about the policy or the language of the policy, and you know, I love Member Molnar to pieces, and I'm not saying you had to use all 16 pages of her stuff, and she had cut it down to 16 pages, but you know, this committee did not pare that down to this one page. So when you're talking about an internal committee and when you're talking about a board committee, we're talking two different committees, okay? And so when the board is dealing with a policy, I would like the board to deal with the policy and not get what's left over from the internal committee. And I think that's where we're starting to lose information. When I came to this committee at the beginning of the year, this page was presented, and it was said, this is what we decided on. Not the committee, whatever internal committee there was. This is what we decided on. So I just want to be clear that this committee did not pare this down. And the 16 pages, Member Molnar, I think it was 16 pages, you said something. Okay, just send that to me. Let me take a look at that. We might cut that down to 8 pages, baby.
You have another comment?
So yes, I definitely, when I presented this to this committee first, I did not expect us to use it verbatim. There are so many things, even reviewing it today, I would change, but I didn't also want it to be perfect because I wanted to leave it open for us to collaborate and to move on and build together. And Member Harrison is right that it is from the U.S. Department of Labor, those definitions, but I wanted to reiterate some of those items in our policy because we had so many gray areas that we have been experiencing at the time. And so some of those items in like item 3 here, because this is what's up on the screen, there are 4 items here. I had 16. Maybe we don't need all 16, but some of them that I think might be worth this committee to discuss. for instance, is that work is not essential. So the success or continuity of a program should not depend on the services of outside independent contractors. That was an item that I had listed that is not here. And the reason I listed it is because that comes directly from the U.S. Department of Labor's definition of an independent contractor. The work cannot be essential and it cannot be ongoing. And so those are just some of the conversations that I wanted to bring to this committee when it comes to this policy.
Okay. Thank you, Dr. Molnar. Let me back up too, just so I'm clear. This is an addendum to this a current policy we already have. Is that correct? Is this part of another policy?
This is,
part of.
go ahead.
Go ahead.
This would be a separate policy from the vendor relations policy. So right now there are two. They're split into two. So there's the vendor relations policy as we discussed previously, and this is a Neola-based policy. This policy has been drafted internally, and Dr. Molinar, I apologize, like that we did look at that line by line, and I think that the intention was to bring the line by line review of that forward, and it just didn't happen, and that's something that got lost in translation, so I apologize for that. But with regard to this is entirely APS created. This isn't a policy that exists anywhere else.
Okay, so this is a new policy, and this will be something that we can work on if we need to, right? Okay, so maybe let's continue to do some work on this here, and then we can keep. Are we on a deadline for this here one? This policy?
No, this is something that we're bringing,
Okay.
so there's no deadline.
Perfect. So let's go back to the drawing board and continue to work with this here. It's not saying it's bad, but just look at it and see what we need to do, if we need to tweak, whatever, and do that. And it sounds like to me, too, that we might need it sounds like it's a form that says we need to go with this. Because Dr. Moore, you're saying check. So if a policy wouldn't be, a form wouldn't be part of the policy, but the policy would be go to this form and complete such and such form. They fill it out, and then they would do it. So maybe let's take a little bit more time on this if everybody agrees. Madam President?
Yes. I think to see the language and see, do we have to have the exact definitions as the federal government? If we're going to work through it as the committee, then it needs to come before the committee, because I don't know if it went directly to Heidi to look at, and the committee didn't really get to digest it. So to your point, it wasn't that anyone did. If the chair at the time gave it to legal, then that's why it went then to the internal committee. But what I would like to say also is, whatever the original, like if the board has this committee will have a responsibility to look over what is provided to them. If it is the original notes of Member Molnar, I do not want, because I don't want an additional bill from your firm, Heidi, is what I'm saying about something that Molinar gave back in whenever she gave it. Because it was a miss in communication. I don't know what it was missed in or how it was missed. I don't want to be charged for it, though. We don't want to be charged for you to revisit it again for a couple of months.
It wouldn't be, sorry,
Okay,
I don't mean to speak out of turn, but no, it wouldn't be revisited. It's something that we still have access to, and we could just forward that on to her and
To the board, yes.
to the board, sure.
Yes, just forward it to us, and yeah.
No problem.
And
Thank
then
you.
we'll look over, and then as we need to advise, if once we chop it up and do whatever we need to do, we'll send it to our lead, who we want to look over it to make sure it's in line. I just want to make sure we're not getting billed again.
Right.
Okay? Thank you.
And the policy should come from the district, come to the committee, and we look at it and we discuss it, and then maybe it goes out to board members, so board members can look at it. If they have any questions or comments and concerns, get back to us on that. And that's the way the actual work should go. Comes from the district to the committee. Committee looks at it, talks about it, discusses it, goes to the board members. Board members get it, look at it, make their comments or concerns, and so forth, get back. That comes back to the policy committee again. We look at it again, insert if we need to insert anything. If we don't need to insert, we won't insert, and then until we get to an actual policy, then we go on to the reading of the policy. So you had a question, Ms. Carter?
No, I was just saying that there was the document that was being referenced. I never had that, but Dr. Molinar just clarified that it was shared with someone, but that person is not with us anymore. So she's going to share this 16-page document that she's been referencing, so that we'll have right.
Yeah, we'll get that cleared up. because it was 16 pages. I probably didn't read it, I'll be honest, until I had time to sit back and read. Okay, any other questions or comments on this policy here? Yes, Madam President.
I think it should start with the committee, because this is the board's committee. If we're getting 16 pages, we should not be sending it directly to administration to get through 16 pages. And again, it's the board's pleasure, right? The majority to say, okay, yeah, this makes sense. And then before we move it on, because that's extra work for them. Like, we can do the basis of the work, and then we send it forward, because again, it's our policies to like kind of chop through. They can look at as far as their day-to-day, the internal work, but I think something like this, we wouldn't even, like, once we look over it and make the comparison and we redline it ourselves, and then give it to legal, it's a reference point then for them. This almost seemed like this specific policy is something we can make the majority determinations, and then edit it or whatever, get it reviewed by legal, and then they can view what we've created and only make suggestions to us about our policy based off of their working knowledge with what they have to do in their positions, is my thought.
Right.
I just wanted to clarify that we're
Right.
not just giving them 16 and then they're going to edit something. They have to do work and give it to, no, we should look over it. We should make the edits based off the work Member Molnar has done, convene when we talk as this committee, and then, like you said, move it forward that way, not the reverse.
Right, and that's only if we come up with the policy. If it's a policy that comes from the district has to, for Neola and so forth, it comes to them, then to the committee. Okay, so we need to make sure if we're doing a policy, let's say, for example, when we did the racial equity policy, that was a policy that was developed by board members, and then we developed it, worked on it, then it went there. But all the other policies basically came from the district, because those are what they have to deal with as far as legal, as far as state, as far as the federal government and so forth. So it goes both ways. So. Okay. Anybody else? Yes, Ms. Carter?
So Dr. Molnar did draft a policy, an ICO policy, and we did go through that policy line by line, and we did make some notes as it relates to things that we could use and things that we couldn't use. And so we can bring that and project it so you can see some of the red lines that the committee went through. So we worked with Mr. Leonard, we worked with Mrs. Folk as it relates to independent contractors and service providers in coming up with the policy. So we did utilize Dr. Molinar's draft. But I'm hearing that Dr. Jackson is saying to send this to you first. Is that what I'm hearing?
Go ahead, Pastor Harrison.
Thank you, Mr. Chair. Policy rests with the board, and so Dr. Molnar does her, I'm going to call hers a 16-page draft. And we know it's not going to look like 16 pages, but that's Dr. Molnar's 16-page draft. It's not for the district to redline and send us back one page. The responsibility for policy rests with the board, policy and finances. And so with Ms. Folk, Mr. Leonard, it's okay if they have suggestions, and maybe it does come back to us, and maybe those suggestions they're far more knowledgeable in certain areas than we are, and they tell us why it doesn't work. But they don't redline it and send it back to us. Okay, they don't just take it out, because we all need to be able to see it. And again, I think that's where we're getting, I think, tripping ourselves up. Policy rests with the board.
Yeah, and Pastor Harrison, I agree to a certain extent, but I'm going to disagree, because only policy that deals with the board, and I think this is where I want to say it, onboarding with new board members and everyone, period, not just Akron, should be understand, because of what we hear all the time, and I've talked to people in the state, and they say, board members are policy people. Yeah, we are to a certain extent if we draft a policy. Now, when we're talking about Dr. Molnar, she did draft that. Okay, yeah, that should have come to us, and then we can look at it and we can go back, or we go bring it to the committee, and all of us here work on it at that point. Then we can go back and make corrections and so forth, but there are still those Neola, state and federal government policies that did not come from us. Those come from them, and they bring it to us.
Mr. Chair, I'm not talking about those, okay?
I was trying to make a distinguish between what Dr. Molnar brought. That would be one that's coming from the board, okay? So that is one that she would get it to us, and we would work on it, okay? And then we go back. Now, the others would come from the board or the district, and we would work on it. But in a case like this, and that's why I'm using Dr. Molnar as an example, since she brought something, yeah, maybe it should have come to us, okay, we worked on it, and then, went back and forth with it. But since it came from her, yes, that's a policy that's coming from her, so it is a board policy. But we don't do the other policies as far as state, federal, and all that. We don't do all those policies. They come to us, and we work on them, but that's not really our job to put those together. If I'm wrong, matter of fact, we'll find the right information, right, and then we'll go. All right, yeah, and then we'll make sure we have it right.
Yeah.
Okay, all right. Anything else on this? We said we're going to bring this one back, and we're going to work on it, and then we'll come back on this one. Correct? All right. Yes, Ms. Carter. Okay. We got a little bit more. We're not quite to an hour yet. We got a couple more minutes. I'm watching that clock, so. Yes, Madam Chair, Madam President.
Just to reiterate, so when a board member drafts a policy, the board member should share it with the committee and the board first. I think what happened is Member Monar shared it with administration, and then I'm sorry, I shouldn't have said that like that. It went somewhere, and then it wasn't reiterated or disseminated amongst because if the member drafts a policy, and most of us are here for that, then the work, if the body decides and is looking through it and it didn't go through the body, then that's a disconnect. That's for any board member, because before it goes further, it should be an agreement with the committee and the policy that, yes, we've redlined it. So I know I've already said that, but I feel like when we're talking, it gets missed. Like the board member introduces, this is my policy, what I want, like the wonderful, the resolution, for instance. It's clearly this agreement. We're just sending it through legal. This is perfect. Like whatever we have to work out, let's work it out. It'll be the same with a policy. As I'm understanding, when the board member drafts that policy, that then it says, this is the policy I've created. It's shared with the committee members, then the board. If they don't make any feedback or anything like that, then whoever, the president or the member will send it through, and then that should go to legal so that we can have one streamline of how it's going to legal, and we're not getting uncertainties or lack of follow through. That's all I want.
That's correct. So there are two different ways of policy. Yes, Dr. Molnar.
Sorry, thanks. If I can clarify just what happened was it was brought to this committee. This committee did have it. Administration asked if they could take some time with it, and that they were going to bring it back after they took some time with it. So that's the process of what happened. So the committee had it, and then the committee transitioned, and so then it fell off. So I think what it sounds like the appropriate next step, since it was here at the committee and it stayed on with this committee, would be to start with where we left off. And so now that administration has had time to digest it, they can then discuss based on what we started with, which, for clarification, the whole document was 11 pages. The actual policy was only 2. It was only 2.
Okay, I think we're clear. If we're not, we'll get it right. All right, how much? I think we have time for about maybe 10 more minutes. Then we're done. Am I right? Oh, shoot! I missed something there. What about this procurement? I had the procurement.
I'm sorry, Chair.
No, I didn't know.
Oh, no, sorry.
Yeah.
We are not doing the 5.01 today, but the 5.02 procurement, Mrs. Cole.
Put these on together.
Okay, yeah,
I'm sorry, I should have been prepared.
That's what I'm gonna have to do, 'cause what we used to do, and I don't know, I hadn't been.
Enlarge it a
policy
little
committee,
bit.
That we used to do, we had it, we could get it to all
Right.
the board members out front. Yeah. Okay.
Good evening again. This is actually a sister to policy 6320. 6325 is your procurement when you are using federal grants or funds. So the changes made to this policy are actually from Neola, and this is an update to meet the new federal standards regarding any items that we receive that are related to federal grants and funds. So they've updated, as you can see in paragraph 1, including the type of businesses. They've now talked about small businesses. They've still left women-owned business and enterprise, veteran-owned, and labor surplus area firms. Yes, sir. I'm sorry.
What is a labor surplus firm?
Those are local companies within your area that may not be employed as much as you would like to in a local area. All righty? And then they've I'm sorry, I'm on cold medicine. Please excuse me. This is an update to this particular paragraph. They've taken consideration, just redone some of this grammatically, and then when appropriate, they've now made it its own statement. An analysis shall be made between leasing and purchasing property or equipment to determine the most economical approach, which we have always done. Under competition, you're now into their CFR Part 200. They've changed some of the wording. Instead of encourage, it now says provide instead of practice. This is just their standards to make them equal to what they want in the federal statutes. Now they've gone ahead and given you examples of situations that may restrict competition, include but are not limited to. So it gives you the ideas of when it is maybe not usable. Yes, sir.
Is this a typo on the competitive bid where it says after 200 good administrative practice, then it has practice scratched off again?
Yes, they moved. There used to be a comma between administrative and practice, and they took out the comma and took out the second practice.
Got it, thank you.
Good administrative practice, comma, and sound business judgment is the way it should read. Okay? Now we just have to go through the next section of changes. Some of these are still here. They just aligned them to specific paragraph. So they deleted the paragraph that starts further. The district does not use statutorily administrative imposed state local. It is not here. It is lower in the, or later in the actual policy. So this is just to bring this to your attention to start going through the changes that has gone through this at the federal level. And to the extent consistent with established practices and legal requirements applicable to recent or subsequent. You have to read every one of these parts because it's part of the CFR out of the federal government. So please take time to look this over. Now we're looking at solicitation language. They have updated that so that you're looking at property, equipment, and service being procured. They've narrowed it down to property and equipment. When necessary, the description must set forth the minimum essential characteristic or standards of that property, equipment, or service. When it is impractical or uneconomical to clearly and accurately describe is an update to that sentence. And then they gave you a change of you cannot use a brand name or equivalent. They want a brand name or equivalent of the feature to provide the procurement requirements may be used. So as an example, you can't put something out to say, I only want a model number X oven. You have to have a brand equivalent or description so that other people may not have, say, a Hobart 440, but they may have an equivalent that can be used as in the bid specifications that they're putting a bid in for. Now, what's important here is the procurement methods that you are required to use with your federal grants. The first one is informal procurement methods. and you read the first sentence, it tells you exactly these are small purchases that expedite the completion of a transaction and minimize administrative burdens. They actually have definitions for each one of these. This is a micro purchase. Please understand the aggregate amount of which does not exceed $10,000. So these are items actually at $9,999 or less. Now, as you go through this, you maintain these documents to support the conclusion of what you're purchasing. There is a drafting note here. Please be very careful. This one notes a drafting note at the bottom. The federal regulation allows for up to $50,000 threshold. While this authority is allowed for an entity qualified as a low-risk auditee, Neola does not suggest its use due to the complexity and subjectivity of the mechanism. It is really hard to do that. And what you would do is you do not check the box that's noted in this policy. And then we're back to what is the Federal Acquisition Regulation, and it's now called FAR. So they updated that section on small purchases. Under sealed bids, and we have now under B, 2 or more responsible bidders have been identified as willing and able to compete effectively for the business. And under the procurement is the procurement lends itself to a firm fixed price contract, and the selection of a successful bidder can be made principally based on price. Now, this is where you get into sealed bids, and the requirements, the bids shall be solicited from at least 3 qualified suppliers. They've changed the definition in section B. The invitation for bids must define the items or services with specific information, including any required specification for the bidder to properly respond. And they've updated D. A firm fixed price contract is awarded in writing to the lowest responsive bid and the responsible bidder. When specified in the invitation for bids, factors such as discounts, transportation, life cycle, et cetera, still are listed, which in determining the bids which is lowest, and payment discounts must, not may, only be used to determine the low bid when the district determines they are a valid factor to be based on prior experience. Under E, the board reserves the right to reject any and all bids. That has always been there, but must document and provide justification for the rejection. It took out just for sound document reasons. You now have to put a document and provide justification for rejecting all the bids that were provided in response to an RFP for sealed bid. And then the proposals was updated, and this is a drafting note. The federal law does not require a competitive proposal unless the procurement is for over $250,000. That is an update. It used to be $150,000. But you can set a lower bid if you so choose to.
Excuse me, Ms.
Yes, sir.
Question.
Go back.
No, when you went past, is transportation a federal bid? Is that a federal grant, transportation?
No, it is not. It's paid out of general fund. These are transportation, unless we use something from sped funds, are all general fund. They are not federal funds that are given for transportation.
Okay, thank you.
And then this just goes through the requirements for the public notice, which we have done for years. To the maximum extent practical, any proposal submitted in response to a public notice must be considered, which we have always done. And then proposals shall be solicited from 3 sources. The district must have written procedures for conducting technical evaluations and for making the selections. And this is gone from a shall to a must and an offer. So this is just updating to meet the federal statutes. Please read it. Now you have non-competitive procurement. And yeah, federal grants are just so fun. Now you have updated this. The aggregate amount of the federal procurement transaction does not exceed the micro purchase threshold. Please remember that is $10,000. The procurement transaction can only be fulfilled by a single source. And sometimes you will see that in our recommendations. It is a single source. Think of items that are related to a specific already approved adoption of curriculum. A public exigency or emergency for requirement shall not permit a delay in resulting for providing a public notice. And the district does request in writing the use of non-competitive procurement methods, and the federal agency or pass-through entity provides with written approval. After soliciting several sources, competition is determined to be inadequate. Then you go into non-competitive purchase agreements, and this is where you can use the ESC, and you've heard us do that. Authorize ESC to make purchases for supplies and materials. We have secured some of our ESC services using this standard. So we're almost done. Procurement of recovered materials is a new section that was added. And this has to do with Section 602 of the Solid Waste Disposal Act as amended by the Recovery Act of 1976. And you keep going through this section's time and material contracts that have been updated mostly for grammar. They have deleted the last part of this. This is also here where you also see for contracts over $25,000, the district shall confirm that the vendor is not debarred. That is a federal debarment statement, goes out in every RFP that we put out. And by providing that information in a bid, you are saying you're not debarred, and we do check that. And this is the section on bid protest. We have to follow these standards, so they updated that slightly. And then the new section here is the retention of records, and all federal records must be held for at least 3 years from the date of submission for financial reporting processes. This is a massive change to this one. It was not updated until recently. We bring this forth for your review.
Okay. I know there's a lot of questions, Dr. Molnar, because this is a lot.
It
here.
is
So,
huge.
We can try to get through some of this if we want, or we can come back with our questions at the next meeting if we want.
I think-
Dr. Molnar, I'll let you.
Thank you, Mr. Chair. I was going to recommend, since this is new business, to bring this for discussion at the next meeting was going to be my recommendation. I also had a question in preparation for the next discussion, because this is for federal grants and funds.
Yes.
But the policy that we looked at earlier tonight, I know it seems so long ago, was for the purchasing and bidding, 6320. Would you consider 6320 as a companion to this for the non-federal, and perhaps the committee would consider looking at these together, because these two might be complementary for each other? And then the last recommendation I would make for that discussion, based on conversations we've been having as a board lately, it feels like the rubrics that are being used, I keep hearing questions about Akron-centric or Akron-focused, or was this taken into consideration? And so here's an opportunity of, while it might not be the federal requirement to consider your city, it might be the will of the board to put something like that in the policy, not the administrative guideline. So I wanted to put all of those out there for future consideration to the chair.
I'm going to ask you to make sure I get that so I can forward it. And we're going to have discussion on that when the next meeting, because this is a lot. This is a whole lot. And I do agree with you, Dr. Molnar. It almost touches on the other policy. When I was reading it, I was like, it's kind of like the same thing. So we need to compare and contrast these two policies as well. Madam President, and you guys.
Yeah, just folks started with saying this was a sister policy to 6320. So like that they are, that's what she's, and when she started off, she said that they are. So, however, like with the recommendations, Member Molnar, but she did state like that they were just in fact that. So I'm in agreement. It's a lot, and I do have questions, but this is a whole nother meeting. We'll be here till midnight.
Right. So if it's okay with everybody, if we bring all our questions back the next meeting, and Madam, Ms. Carter, can we start on this one, maybe our first policy maybe, since it's so much, or you guys have other policies that need to get put in before this one?
No, I know that we had talked about doing the special policy meeting on June 2nd.
Oh, that's right.
At 5:30 to discuss the handbook for CLCs. And I know we don't like long meetings, so maybe just putting one item on that special board meeting So I don't know what's your pleasure as it relates to what would go on that agenda.
Do we think that, we know we're bringing that to the committee, the one, on the special meeting, and well, we're going to have a special meeting for the policy committee, so we can get something that needs to be done before a certain time. So we're going to have an additional meeting. Yeah, I'm sorry. We had talked about that. Ms. Carter just mentioned it to me this week. So we're talking about having an additional policy meeting. Yeah, you had a question, Pastor?
No, it was something to you.
Oh, okay. Okay. All right, so the next meeting, you said that the next one will be the special meeting, and so the next special meeting, we want to bring the booklet.
The handbook for CLCs.
Yeah, I'm trying to think, do we want to put anything else on the agenda? I know this here was going to take some time.
If we don't call it a special meeting, it's a call meeting, and then they can.
Oh, yeah, just a policy meeting. I mean, yeah.
Okay, so we'll have the special meeting. We'll touch base. You and I touch base on the book, and if we need to put something else on the agenda, and then we'll get it out. Make sure we get it out to everyone, because when we do this here, I want to make sure that everybody has this and have their questions when we come back, because this is a lot of information. Please I hope you're here next meeting so you can bring out these questions.
You're gonna send some stuff.
Right. Okay, Ms. Autry.
Thank you, Mr. Chair. And so I don't know where this goes. I think I sent you a copy of Cleveland Metropolitan School District's policy on honorary diplomas. And so it doesn't need to be at the special meeting, but hoping we can get that on a future agenda as well.
We'll get that on the agenda for sure.
So does that fall under coming from a board member, or because there's an existing policy we can build on?
It does come from a board member, because we're bringing it to our board, even if it's
Okay.
part of another district's board policy, and we're bringing it to us. So then we're going to probably look at it, possibly tweak it, and then develop our own policy. So that would be something that come from board member to the board, and then we can bring it up to discussion
Thank you.
at the committee meeting. Any other questions? Yes.
So just one last thing from me. July 1st, we're required to have the Parents' Bill of Rights policy on the books. I just wanted to make sure that we're all aware of that deadline.
Okay. You said
July
okay.
1st.
So we have a little time, but we need to make sure we have it on there. Bill of Rights. Okay. Anything else for the good order? Am I missing anything? Anybody? No. If nothing else, we will adjourn this meeting. Thanks, everyone, for tuning in. Thank you, all board members, for being here.